Hello dear students, welcome to Bajirao Ias Academy interview guidance program. In previous lecture we had talked about the issue of secularism. So how secularism is very important for a country like India, and how the structure, the secular fabric is being eroding in recent past, and what measures have to be taken in order to strengthen and protect the secular fabric, and what are the constitutional provisions of the secularism, even though secularism is not directly mentioned anywhere in the constitution except preamble, right? So the another contested and most important topic for your interview is the governor, the institution of governor, or the office of governor. In recent past, the office of governor is in news. So why it is in news? So it is in news because of few reasons. So one is arbitrary imposition or recommendation of article 356 of the Indian Constitution. So article 356 of the Indian Constitution related to the imposition of president's rule in a state. So whenever there's a failure of the constitutional machinery in the state, so whenever the state does not follow the directions given by the center, so in all those aspects, the governor can recommend imposition of president's rule in the state. So the arbitrary imposition of such president rule in the states is one reason for the issue of governor. Okay, so the office of governor is in news. And apart from that, in recent times, in states like Madhya Pradesh, Karnataka and Maharashtra, the governor has been involved in the fall of opposition governments, right? So that was also questioned by the Supreme Court. So since governor is expected to play a neutral role, so governor acting as the agent of the center and involving in the fall of opposition governments in those states is another factor why the office of the governor is in news. So the other major reason is, if you look at the governor of West Bengal, Telangana, Tamil Nadu and even the Kerala, so they were also in news. If you look at Tamil Nadu, the state legislative assembly passing certain bills, so it have all the powers to pass such bills. So however, the governor is refused to give assent to those bills. So when governor is not giving assent to those bills, they will not become any laws. So this is what is happening in Telangana also. Okay, so with the earlier government. And apart from that, if you look at Kerala, there was also a frequent conflict between the elected government and the office of the governor. So because of all these reasons, the office of the governor is in news. So therefore, we need to understand what are the constitutional provisions. So what exactly the constitution mandates when we talk about the office of the governor? What are the constitutional provisions? So what are the discretionary powers of the governor? And what are the constitutionally guaranteed discretionary powers of the governor? So all those things we will understand. In interview, you may get some questions on the office of the governor because it is in news. So we will try and explore more dimensions with respect to the office of governor, right? So firstly, why the office of governor is in news? Now, if you look at the office of the governor or the position of state governor, it holds a lot of importance in our political system, right? So it is like what the president of India is at the center, similar to the president, we have the governor at the states level in order to protect the constitution, right? So he is a constitutional head. He is not an elected head, but rather he is a constitutional head at the state level. So because of this reason, the state governor have a lot of importance in our political system. And he also serves as a crucial link between the center and the state governments. And in fact, the Sarkaria Commission has termed governor as the linchpin between the center and states. So therefore, in this context, it is regarded as a pivotal element of our democratic governance, emphasizing on cooperation. So emphasizing on cooperation between the elected government and the governor, right? So that even results in poor governance when there's no cooperation between the elected government and the governor. So therefore, in the context of recent dispute between the Kerala government and the governor, and Tamil Nadu government, elected government and the governor, and even at the West Bengal, Telangana. So because of all these reasons, the office of the governor has assumed the central or significant position in news, right? So in this context, we need to understand the constitutional provisions which are related to the office of the governor. So what are the provisions which related to the constitutional the office of the governor? So firstly, we need to talk about Article 153 of the Indian Constitution, right? So Article 153 says that there shall be a governor for each state. Okay, so each state will have one governor, right? He is the constitutional head, right? So one person can be appointed as a governor for two or more states. So not just the one governor for each state, but one governor can be appointed as the governor of two or more states. So this is what Article 153 of the Indian Constitution says, right? So when you look at the appointment of the governor, so governor is appointed by the president, right? So the governor is appointed by the president at the state level, because he is not the elected head, rather he is the constitutional head who is appointed by the president. So therefore the president, by warrant under his hand and seal, appoints the governor, and he also holds his office till the pleasure of the president under Article 155 and 156 of the Indian Constitution. Okay, so he also in his office, or the governor does not have any fixed tenure. The Constitution has not mandated the fixed tenure for the governor. So since governor lacks the fixed tenure, so he holds office till he enjoys the pleasure of the president under Article 155 and 156 of the Indian Constitution. So what Article 161 says? So Article 161 states that governor has the power to grant pardons and reprieves. Now there are certain pardoning powers of the governor. Similar to the president, governor also have certain pardoning powers. For example, commutation, remission, pardon, reprieves, respite. So all these things comes under the pardoning powers of the governor, right? So Article 161 specially talks about these powers of the governor, Article 161. And there's another article, Article 163 of the Indian Constitution. So Article 163 states that there shall be a council of ministers. So we have the federal form of government. So we have the federal government and units at the state level. So similar to the federal government or the government at the center level, we also have the council of ministers at the level of state government. So the council of ministers are headed by the chief minister. Okay, so council of ministers are headed by the chief minister, and the governor actually works on the aid and advice of the governor, aid and advice of the council of ministers headed by the chief minister. For example, whenever the governor exercising his functions, whenever taking major decisions, he takes the advice of the council of ministers headed by the chief minister, and this is what Article 163 of the Indian Constitution says. So there is another article, Article 361 of the Indian Constitution. So what does this article talks about? So Article 361 states that whenever the governor takes any decision, okay, so whenever the governor takes any decision, he shall not be answerable to any court of law. Okay, so in exercise of his powers, his duties, he will not be answerable to any court of law, and that is what Article 361 says, right? So because of Article 361, so it ensures there's a separation of powers between different institutions that is mandated by the Indian Constitution. However, there's no strict separation of the powers. So but Article 361 is in line or is in conformity with the separation of powers. So therefore the governor can work in a more effective manner because of Article 361, because he is not answerable to the any court of law in exercise of his powers and duties, and these are the relevant constitutional provisions with respect to the office of governor. And after that, we need to talk about certain discretionary powers. So governors have certain discretionary powers similar to the President of India. Now, what are those discretionary powers? Now, these discretionary powers can be divided into two types. One is the constitutional discretion of governor, and second, the situational discretion of the governor. Now, when the governor uses the constitutional discretion, okay, so firstly, so when they have to reserve the bill for the consideration of the president, right? So in this case, when state legislative assembly passes a bill and send the bill for the consent or send the bill for the assent of the governor can reserve the bill for the consideration of the president. So this is particularly during when the bill endangers the position of the High Court. So when the bill has any provisions which is against the directive principles of state policy, so in those situations, the governor can reserve the bill for the consideration of the president. And this is the first constitutional discretion of the governor. And secondly, the second constitutional discretion of the governor is when he has to recommend for president's rule of the state. Now, Article 356 talks about the president rule, imposition of president's rule in a state. So when a president has to recommend imposition of the president's rule in a state, then also he uses his constitutional discretion under Article 356 of the Indian Constitution. So apart from that, whenever the governor has been given an additional charge with respect to the administration of union territory also, he will use his own constitutional discretion. Now, we have discussed when governor enjoys the constitutional discretion. Apart from this, governor also have certain situational discretion, right? So the situational discretion, whenever he is appointing the chief minister after no party gets clear majority or when the incumbent dies in the office. So the incumbent chief minister, if he dies in the office, then the governor enjoys some situational discretion when it comes to the appointment of another chief minister from the same ruling party or the party which has the largest number of seats. Okay, so even after elections, the governor enjoys the situational discretion who should be appointed as the chief minister. The leader of the largest political party will be called to form the government if he had the required majority, right? So if he does not have the required amount of majority, required number of majority, then the governor will call the pre-poll alliance, any party which has pre-poll alliance and which gets majority number of seats, okay, so or which crosses the magic number. And this is where this is what the first instance where governor uses his situational discretion. After that, when he dismisses the council of ministers on an inability to prove confidence in the legislative assembly. So right, so no confidence motion is being introduced in the state legislative assembly, and that led to the fall of the government, or he dismisses the government after the no confidence motion. So then also governor enjoys some degree of situational discretion with respect to appointment of the another chief minister. And when he dissolves the assembly, when it loses its majority, then also he uses his situational discretion. So in this respect, there's some Supreme Court judgment with respect to the discretionary powers of the governor. So execution of discretion beyond the constitutional permissibility is considered attack on the elected government of the state and people's mandate. Now, what does this mean when we talk about the role of the governor in using his discretionary powers, right? So the elected government, dismissal of elected government amounts to the violation of the mandate which is given by the people, right? Because ultimately people have elected the political parties. So therefore, execution of his personal discretion or situational discretion, which is beyond the constitutionally permissible limits. So that can be considered as an attack on the constitution, an attack on the people's mandate, right? So in this context, we need to talk about the issues which are related to the post of governor. So there are certain issues which are related to the post of governor. So first issue is affiliation based appointment of the governors. Now affiliation based appointment means that the former bureaucrats and the former leaders of the same political party are being appointed as the governors of various states, and there were instances that the Supreme Court judges are also appointed as governors. For example, the former Chief Justice of India, Sadasivam, was appointed as the Kerala governor. Okay, so there were instances in the past also where the affiliated members of a particular political party or biased bureaucrats are being appointed as the governors of different states. So therefore, when affiliated or affiliation based appointments are being made, so this will raise questions about the post impartiality and non-partisanship. So essentially it is expected that the governor have to maintain the post impartiality and non-partisanship. So this certainly has a lot of impact. Now after that, we need to talk about the other thing, that very often governor has been acting as a representative of the center or agent of the center, right? So therefore, critics refer governor as the agent of the center today. So they are being considered as agents of the center because they are recommending the president's rule in opposition ruled states. Secondly, the governors are being involved in the fall of the state's government in Maharashtra and Karnataka, Madhya Pradesh. So because of this reason, critics have been saying that governors are being acting as the agents of the center today. Now after that, the misuse of discretionary powers is also another concern. So we have talked about certain discretionary powers of the governor, situational discretion and the constitutional discretion. Now the situational discretion is being misused by the governors. That we have seen during Tamil Nadu issue, the conflict between the elected government and the governor, where the governor has been withholding the assent to the bills which are passed by the state legislative assembly. Okay, so when we talk about the example of this, it has been argued that critics of the governor's recommendations to the president rule in a state has not always been based on the objective material but on a political whim and fancy, right? So there's no objective criteria which is being followed whenever they are recommending the president's rule in a particular state. Okay, so it is just based on the whims and fancies. So their biasness, since they are acting as agents of the center, so they are just recommending the president's rule in a opposition party ruled states. So after that, the removal of governors is also another issue. So whenever the government changes at the center, the governors who are earlier appointed by the opposition parties will be removed. So this is there's no proper criteria for the removal of governor because there's no fixed tenure that is guaranteed by the constitution for the governors. In fact, they work on the pleasure principle. So they will enjoy, their tenure is actually dependent on the pleasure of the president. So because of this reason, removal of the governors is also very often a contested issue. Now apart from that, there are certain constitutional reforms that are being suggested by various committees and even the Supreme Court, right? So here there are different committees. For example, the Sarkaria Commission, the Poonchi Commission, National Commission for Review Working of the Indian Constitution, and even the Supreme Court has also recommended certain reforms in the office of the governor, so that it can act as more impartial, non-partisan manner, right? So upholding the constitutionality and the constitutional principles. So if you look at the Sarkaria Commission recommendations, basically all the reforms or suggested by these committees are same. So if you look at the Sarkaria Commission recommendations, this commission has given recommendations in the year 1988. So the governor should be appointed by the president after consultation with the chief minister of the concerned state, right? Now, the general convention in appointing governors to a different state is, first, the president will consult the chief minister while appointing a governor, so that there will be no conflict, there will be no tussle between the elected government and the governor. Okay, so this is what the Sarkaria Commission has been recommended whenever it is related to the appointment of the governor. But very often this recommendation has been sidelined. Presidents rarely talk to the chief ministers whenever it is related to the appointment of the governor. Secondly, the second most important recommendation is the governor should be a person of eminence. So any person cannot be appointed as a governor, rather he should be a person of eminence in some field of public life and not belong to the state where he is appointed. He is an outsider and he should not belong to the same state where he is appointed, and he is a person of eminence in the field of public life. And the third important reform is that the governor should not be removed before the completion of his term. Generally, governor enjoys 5-year term, but that is not constitutionally guaranteed. So his tenure is actually based on the pleasure doctrine of the president. So therefore, the governor should not be removed before the completion of his term, except in a rare and compelling circumstances. Now, after that, the governor should not act as a bridge between the center and states. Okay, he should act as a bridge between center and states and not as an agent of the center. So in fact, the Sarkaria Commission, the Poonchi Commission has said that the governor should be a linchpin between the center and state governments. So he should not act as an agent of the central government. Rather, the governor should act as a bridge between center and state. So after that, the governor should use his discretionary powers sparingly and judiciously, and not use them undermine the democratic process. So his personal discretionary powers or the constitutional discretionary powers should be used in a more judicious and sparing manner. Okay, so therefore he has to uphold the constitutionality and the constitutional spirit, and he should not act as a mere agent of the center government. Rather, he should uphold the federal principles and the powers of the governor, powers of the state government as per the constitution. So that is how we can strengthen federalism. So, right, strengthening federalism is very important for a federal polity like ours. So that's all about the office of the governor. So you just remember these reforms. Okay, thank you.